We are good to go.
Thank you. All right. Good afternoon, everyone. My name is Atia Mosley, and I am Chief Legal Officer. Welcome to Child's Voice Project's September's Roundtable. These roundtables serve as a place for knowledge sharing and learning, and we are building a clearinghouse of research-based best practices for child-centeredness, and we invite you to bring your ideas and questions to these forums. If you were with us last month, you heard us discuss the child's voice and reasons why being heard matters to the child and how it can help adult decision makers. If you missed the event or want to watch that session again, a bit later we'll be putting a link in the chat to our YouTube site. As a reminder, in case you want to place a hold on your calendar, we hold these roundtables on the third Wednesday of each month at 1 p.m. Eastern. Now, originally today, we were going to go deeper into an exploration of children's voices and what occurs when we honor them. We will go back to that subject and related topics next year. Today, though, we're going to be introducing our Guest Expert series. Through this series, we will interview experts in the field and invite you to ask questions of these seasoned professionals. This furthers our knowledge sharing and learning goal. During some of our prior roundtables, we have referenced our Maryland Child Advocate Attorney pilot program, where we provide a child advocate attorney for children in their parents' custody actions. Our pilot program attorneys are specially trained on child development and child-centered relationship building. We also use a model of incentivizing the attorneys to develop relationships with their child clients. Establishing and evaluating our pilot program is one way that we are creating a world where every child is heard. Today, we're going to introduce you to our local Maryland partner who helped us get the pilot established. And then next month, we will introduce you to some of our pilot program attorneys. Now, we are kicking off this new series with an exciting interview of Connie Kratovil-Lavelle. While we are speaking, we invite you to go ahead and type your name, location, and professional identification in the chat, as well as your comments and questions. We believe our time together will be better because of your participation. So let's go ahead and get started. Welcome, Connie.
So hello, sorry, again, I haven't been able to figure out why the video isn't working. But thank you, and I'll just be a voice today.
Well, we are happy to have you here in any manner, and we are really excited that you are joining us as our first guest expert for our new series. We look forward to learning more about you. Will you start by telling us, please, where you live and one awesome thing you did this summer?
Okay, so I live on Kent Island in Maryland, just over the bay from Annapolis. And I've done so many awesome things this summer, it'd be hard to narrow it down, but um, since you did ask me about it before, I thought about it. I went scuba diving last month with my kids in Puerto Rico, the southern part of the island. And one dive in particular was fantastic because we were communing with a great big huge sea turtle who was so interested in us that it was a fella, this big guy came up to each of us. We kind of suspended in the water so as to not startle the turtle, or turtle wasn't scared at all, came up to each of us, did a nice sort of frank assessment of us, kind of went around, and then kind of floated off. And it was absolutely an awesome moment.
I love that. I love that. And as you said, you had a long list of awesome things you did this summer. So thank you for sharing that with us. That sounds so exciting. Connie, when you and I were preparing for today's session, you identified yourself as our State of Maryland local partner. Will you please explain to us your role at Child's Voice Project?
Certainly. So my role has been to help the Child's Voice Project set up a program in Maryland because Dr. Steph Sloan had identified Maryland as one of the few states, probably about 10 states, that authorizes the court, a judge, to appoint an attorney for a child in a custody matter and to appoint in one of three roles, but the role that you all were interested in was as advocate. So I have helped the Child's Voice Project get in touch with, meet with the courts. I used to be with the Maryland Judiciary, probably for about 10 years. I ran the an office of the Maryland Judiciary that oversees domestic and juvenile policy and programs. So I know the court. So I kind of did first introductions, and frankly, that's all I thought I was going to be doing. And then you all sucked me into all this other business, which has been the most fortuitous, unexpected thing, and one of the best things that's happened in a couple of years. So that's my role, kind of introducing the Child's Voice Project to the court, getting meetings set up, and then I've been something of a um, Maryland law kind of consultant, helping Child's Voice Project um, learn the ropes, understand the law in Maryland, some of the obstacles, that sort of thing. I'm your asset in the field.
Awesome. I love that. And how did you first learn about our project? You mentioned Dr. Steph. Can you tell us a little bit about what that initial contact was like?
So again, it was one of those unexpected, fortuitous things. I was sitting where I'm sitting now at my home office at my desk. I hadn't expected, it was about 2 years ago, 2.5 years ago, maybe. I hadn't expected to be at my desk. I was supposed to be doing something else that was postponed. So I was checking my emails, like some Dr. Steph Sloan, University of Kansas. I'm like, what is this? And Dr. Steph Sloan was asking if I could provide some background information on the child counsel law in Maryland, because Steph, I now call Dr. Sloan Steph, had I was referenced in some ABA, American Bar Association article from the early 2000s. So I'm reading this email and I sort of laughed and I responded. Those who know me know I'm kind of down to earth. And I responded in the way I often do, which was I'd have to think about what I was doing in the early 2000s. But if you want to talk, I'm actually available now because I was supposed to be somewhere else. We had a conversation. It's a pretty long conversation, and we just found all kinds of areas of overlap. And I thought I was just gonna give a little bit of background and help the Child's Voice Project, which was still forming. By the way, this is early stages. My thoughts were I was just going to give a little bit of background and provide some insight into the rule and lawmaking process regarding child counsel, and then I'd go on my merry way. And here we are at the September Roundtable, 2.5 years later.
I love it. What about the mission as you understood it then that captured your interest?
Oh gosh, so everything about it. So the mission, improving outcomes for kids, families by amplifying the child's voice. So first of all, who's against improving outcomes for families? So that was pretty easy. But having been, and at the time, 2.5 years ago, having been a practicing attorney for decades, private practice, and in state government and working for nonprofits, over half my work over the years was family law.
Mm,
And it's kind of ironic that I ran the kind of family law department, if you will, for the Maryland Judiciary. And I, as a practitioner, and then later in my various roles, um, came to be painfully aware that the litigation process is often terrible for families, and improving outcomes by having a better process, by giving voice to the child, or children makes such sense, because if whatever our problem is, whatever the conflict is, hearing the voices of everybody, including the
Right.
children, makes for that's more information. It makes for better outcomes. It People are more likely to reach agreement. So the mission about amplifying the child's voice, in child welfare cases for years in Maryland and all around the country, kids in foster care cases, we call them CINA cases for those of us who are in Maryland, child in need of assistance. Those kids get voices, and everyone seems pretty comfortable with that.
Right.
But not so, not uniformly. Hey, Patricia, in custody cases. So I believe it in giving voice to children, and because largely, or zooming out, I believe giving voice to everybody affected by a conflict, whether it's a domestic conflict or a nation state conflict. Better outcomes when we hear the other perspective. So it fully aligns with my philosophy, and frankly, one of my guiding principles.
That is wonderful. And it sounds like those have been your guiding principles for some time because you're the executive director of Collaborative Law and Justice Center, which is one of um, two nonprofits that you founded. Will you tell us a little bit about that work?
Right, and just to be clear, so that is, I do that on the side. That's like my Saturday, Sunday morning and evening job.
Okay.
So I have my full-time gig. I'm the deputy director of Maryland Disability Rights Center. So
Okay.
they get they get more than 9 to 5, but I do this on the side.
Okay.
So the Collaborative Law and Justice Center, boy, is an organization that is both a legal service organization and a social justice organization. And by the way, the social justice side is probably going to eclipse the legal service side. But initially, I started this a few years ago in order to provide affordable, free, pro bono, or reduced fee collaborative law services to parents in contested custody cases. So I don't know, we don't really have a way to poll. How can we ask people participating if anybody knows what collaborative law is?
So people can answer in the chat if they'd like to, or they can raise their hands or their electronic hand.
All right, we see. Okay, I'm going to give a quick, how about I do a little footnote and give a quick little explanation of collaborative law.
Sure,
All
great,
right.
thank
So collaborative law is an alternative to litigation, like mediation. But with collaborative law, um, parties in a case, and collaborative law started with divorce custody cases. It's expanded a little. I won't get into that today, but boy, I could
you.
get into that and talk all day about it, but I won't. Um, so with collaborative law, let's say in a typical case, which is a divorce and custody case, everybody agrees, everybody are the two parties, let's say the mother, the father, the husband, the wife, if they're married, and their attorneys all reach an agreement. By the way, it's a written agreement, like a contract, that says we're going to do everything we can to reach an agreement, solve this conflict, this issue without litigation. And should we not resolve, and we're going to do it through we lawyers would see as like an open, ongoing discovery process. I don't compel the other side to give me information I need or want. We
Okay,
all agree to give it up, to give the information the other side wants. We don't hide things. You don't hide bank accounts or I'm not going to tell you the name of my new girlfriend. None of that business. Everything is on the table, and the lawyers commit to making sure their clients do that. Should they not reach agreement, then the attorneys are prohibited from representing their client in the contested divorce or custody. And
okay,
that gives um, a lot of incentive for the parties to try to reach an agreement so they're not wasting their time and other resources. So lawyers, what I like to think are decent, good family law lawyers have been de facto practicing this anyway.
Okay.
Because again, lawyers are problem solvers. And as a matter of kind of philosophy and ethics, when I was practicing and doing a lot of divorce custody cases, I figured unless, my client had a personality disorder or something, they probably wanted to resolve the divorce custody issue as quickly and painlessly or with less pain as possible.
Right.
Less money, less time. So, but this has become, this is now codified in Maryland, and myself and others played a part in this becoming a statute in Maryland. So, I started this organization to help help people get access to the collaborative process because
Okay.
generally the kind of people who have used the collaborative process are very well-heeled clients who want a more civilized divorce custody dispute. They don't want all that nasty fighting in court, but they usually have a lot more money. So the idea was with this organization was to make it more accessible. So that's what collaborative law is. That's why I started this organization because after 30 some years of being a lawyer, there's a better way to resolve the conflict.
Yeah, and that definitely makes sense. And as a prior family law attorney myself, what you're saying rings very true. I'm curious, how does this passion that you have for conflict resolution, which is what I'm hearing you speak about your passion, how does that play into the work that you're doing with us at Child's Voice Project?
Well, going back to how I initially became acquainted with Dr. Steph Sloan and all of you at Child's Voice Project was 2.5 years ago when Steph and I had that initial conversation. And when Steph was describing some of the research that had been conducted using the child advocate model, and that model was a model that was being used at the time in North Carolina. The findings were that the parents were much more likely to reach agreement when they heard the child's perspective. So all of that makes sense. I'm not a diplomat and I've never studied diplomacy. I'm assuming, the Kennedy School of Government at Harvard probably has Diplomacy 101 or something, but I bet in Diplomacy 101, first day on the syllabus is conflicts are resolved when people get together, know each other, and hear the other's perspective. So it just everything about that makes sense to me, and it didn't really surprise me the findings that the parents were more likely to reach agreement, but that was now I'm forgetting what your question was.
It's okay.
Sorry.
No, it's all good. And you're speaking to something, and as a just a reminder to people, Connie mentioned the program here in North Carolina, which is the program that I've worked at and then ran for years. And that was definitely something that we saw over time. And as mentioned before, as a family law attorney, you're hoping that there's something that will make the process easier for children. And we found that children being directly represented helped in that process. So definitely what you're saying is based in my experience as well. And so, and you touched on it. My question was, how does your passion play into the work you're doing at Child's Voice? And I'll ask a follow-up, which you've already touched on, which is how do you see children having a voice? How is that then potentially impacting the alternative dispute resolution process, which you've already, explained to us? How do you see children having a voice in that setting versus in a litigation setting?
So I think in either setting, the child having voice makes for a better outcome because there's more information before the decision maker, whether the decision maker is the judge or magistrate, or whether the decision makers, plural, are the parents. Having the perspective. So in either forum, um, hearing the child's voice makes the, not makes, that sounds so forceful, but it allows the parents to see, or the judge, how what how the parents' conflict is affecting the child, the how it may be adversely affecting the child, how the child, what the child wants or desires or needs. Amplifying that voice makes the parents or the judge more likely to consider it and to see it when a heretofore maybe that wasn't recognized. So that's my longer answer to your question. But I think in either form, and just to be clear, I'm not anti-litigation. I mean, sometimes we got to fight, you know. I mean, work it out when you can work it out. But listen, sometimes people are not reasonable. And by the way, here's my plug for us lawyers. When people give us a hard time, you're a lawyer, boy, you're always making a lot of money. I'm like, listen, if people were more reasonable, we wouldn't need so many lawyers. So I think kind of connecting that, I think that hearing the child's voice, whether it's in litigation or in an alternative forum, is makes for frankly more just and dare I say reasonable outcomes because it's more comprehensive.
Excellent. Thank you, Connie. I'd like to now transition a little bit to something that you mentioned earlier about your work with the judiciary. And so, can you tell us about your experience prior to your current roles that gave you access to Maryland's judiciary?
Yeah, it actually goes before that. So I was, it's funny because this is also related. This is, by the way, I enjoy this. I love working with you all and taking my little lunch break late to do this. And thank you for inviting me. Um, so I was sitting in my office in 2007. I had just finished another terrible divorce custody case, and we quote won. And I felt terrible, because if you can't work it out, um, you got to kill the other side. Obviously, I don't mean really kill the other side. I guess I should be careful in today's environment. I mean, you got to go for broke, and it felt terrible. And I got a call. Um, I think it was the afternoon when I had, got out of court. I'm sitting there, thinking I should probably do an invoice or whatever. And I got a call from a woman who some of you may know. She's a legend. Her name's Pam Ortiz,
Hmm.
and she was the first executive director of the Department of Family Administration within the judiciary. She recruited me to be her deputy. So that
Wow.
was in 2007. So that's when I formally, contractually began working with the judiciary. And within a year, then I guess a year and a month or so later, I became the executive when Pam moved on. Um, that job required me, which I loved, to help the what we now call the Chief Justice of the Maryland Supreme Court, to ultimately help the Chief Justice develop policies and then programs related to domestic and juvenile law. So, as part of my work, myself and the other attorneys in the office, we staffed all of the committees of the Maryland Judiciary that
Okay.
have anything to do with domestic or juvenile law. In meetings, many meetings during the week. And I came to work very, very, very closely with the judges around the state,
Hmm.
the judges who were and who are leaders, who these are the ones who, because being on these committees, these meetings were usually at night, 6 to 8 p.m., because they've got dockets. So these are
Right.
really committed judges and magistrates. So that's how I came to be familiar. But before that, Achia, in various capacities, was often recruited to be on these committees. Like, for example, it's actually how I met Pam Ortiz, is work I've done in the domestic violence context. I was on a work group, there are like five of us, I guess, who drafted a policy for the Maryland judiciary to screen out cases that wouldn't be appropriate for mediation of child custody. See, it's all connected here. I didn't
Yes.
intend this. If you would ask me when I was 5 or 21, what do you want to be when you grow up? It wasn't this. I don't know how this happened, but here I am. Um, so that's the long answer to your question about how I came to be so familiar with the judiciary. And currently now, I mean, is it tonight? No, it's only Wednesday. Tomorrow night.
Mhm.
I still sit on various committees of the judiciary. Like there's only two standing committees of the Maryland Judiciary. One's what we, in short, call the Rules Committee, and the other is the Standing Committee on Pro Bono Practice. And I've been on the latter for, I don't even know how many years, 10, 15. I don't think it's 20. And then I interface with the judiciary many times a week in my role with the State Bar Association as the co-chair of the Rules Committee. So, and those of us on the call who are lawyers, the rules are a big deal. The hearsay, all the law about hearsay are pretty much the rules. And of note, the rule about child counsel is a rule, and I bet you're going to ask me about that later. So that'll be a little filler.
Actually about to ask you right now. So, and you did, you referenced it earlier. You told us that Maryland is one of about 10 states that allows for a child advocate attorney or some kind of other um, term which provides the child to have a counsel and have their preferences expressed. Can you share with us how a child advocate attorney is actually defined in Maryland?
As a matter of fact, I can. So there's a couple of places where this is defined, but probably the best place to find the definition is in the guidelines that accompany the rule. And the rule, and a lot of you all, I'm sure, know this, is 9-205.1. So that's the rule that was adopted. It's a rule that actually I started drafting in 2006 before I was with the judiciary, but it was back in 2006. And then the what we now call the Maryland Supreme Court adopted it in 2007. And when they adopted the rule, they also adopted guidelines. You all probably have seen, a lot of you on the call have probably seen the guidelines there. I should know this, probably 4 pages and really small font, um, single spaced. So the best definition is probably in the guidelines, and I'll read it for you. So the child, and under the definitions in those guidelines, the child advocate attorney means a lawyer appointed by a court to provide independent legal counsel for a child. The term replaces the less specific phrase child's attorney, and I can talk to you all day about legislative history with that, which, being the nerd that I am, I'm like fascinated by all this. If we have time, I'd be fun to talk about that, or at
Okay.
least it'd be fun for me. It might not be fun for you all. But so it replaces the less specific phrase child's attorney. A child's advocate attorney owes the child the same duties of undivided loyalty, confidentiality, and competent representation as are due an adult client. So same as an attorney is an attorney, whether your client's a minor or not. A child advocate attorney should be appointed when the child is in need of a voice in court. By the way, when is the child not in need of a voice in the court? Maybe when they're not a child. I mean, we can talk about that. But then the guidelines then kind of list some things where that might be the case, such as relocation, when there are allegations of child abuse, or where the child is sufficiently mature. And Dr. Steph Sloan could talk about that a lot with you all, and sees his or her interests as distinct from the interests of the parties. So that's the definition, and I'll do a little trailer on the legislation. Before this rule and before some other statutes, it was back in the 1970s when Maryland first kind of codified the authority of a court to appoint an attorney for the child.
Right,
And there's some debate about this, but I think there's a very strong argument that the legislative history, which I have had occasion to dig into,
right.
um, there's a strong argument that when the Maryland General Assembly first codified the authority of a court to appoint an attorney for a child in a custody matter, they meant an attorney like we all think of an attorney. They did not distinguish
Right.
advocate, and we used to say guardian ad litem all the time. Now that's replaced by BIA, and it wasn't until later, like 2006 to maybe 2008, um, when the Maryland General Assembly wanted to distinguish an advocate from a BIA. And actually, our statutes are not where we really get the definition. The definition are in the rules. And
Mm.
this gets into probably deeper than we want to go, but it is, like I said, a little fun. I think my take now, the 1976, that was before my time as practicing, so we can be clear. Um, and, so I wasn't in I wasn't digging around the written testimony or fiscal notes at that time. I was still a kid. But my reading of it, sort of extrapolating from all the testimony, is that initially the the idea was the attorney should be an attorney. And
Mhm.
it just so happens the client is a minor. It's not till later that there was the distinction made. And I think that's interesting. And I'm guessing that the General Assembly did not enumerate the distinction, didn't distinguish so much in the various definitions because there was some debate about it. And I don't know how many Marylanders might be on this call, but I think probably then Delegate Dumais, who is now a judge in Montgomery County, probably has a lot to do with that. You might want, by the way, and I could maybe help get Delegate Dumais to even fill in a little bit more. Although she'll be a little more limited because she's in the judiciary now. So there's got to be a little careful about doing anything that looks like advocating.
Yeah.
Um, yeah.
So, and yeah,
So
and I
that's
appreciate that. So, for those, because not everyone who will see this is an attorney, and not everyone is an attorney in Maryland. So, you use the acronym BIA, which is Best Interest Attorney, and the way that I distinguish for people who perhaps are not attorneys or not in Maryland is the difference between whether or not I am substituting my judgment for my client's judgment. And that is sort of, different places, different jurisdictions have different terms, but that is the general idea is, am I representing the child's preferences based on what they're telling me, or am I making up my mind and making a decision based on that? So that might help other people. And I do want to know, before Child's Voice Project started in Maryland, do you have a sense of how often child advocate attorneys, as the phrase is used in Maryland, how often that actually took place?
I have a sense. I don't have data, so I'll
Okay.
start with that. And that data is not collected. And I could go on and on and on about the MDEC, which is our electronic case filing and data, and Maryland Judiciary Statistical Abstracts, and that's some fun reading. That has a lot of data. That is not collected. And actually, I wasn't being facetious. For me, that is kind of fun reading, but um, that data is not collected. So when Steph had first contacted me,
Mhm.
I had said, I'm not sure I've ever seen except in the child welfare context,
Right.
child abuse, neglect cases, adoption. Um, I had never personally seen a court appoint a child's attorney in the role of advocate. So
Interesting.
I ended up, and this is just after the first call because I was so very interested in this
Right.
project. I did my own little survey. So, for those of you who are statisticians or like Smarty Pants Dr. Sloan, this was not scientifically valid, my little survey. Um, but I do think it nonetheless was statistically significant. I sent out a survey to the family law practitioners, the State Bar Association, and those who responded, which was not a massive percentage. Only two, I think, had been appointed as an advocate. So I would say, and I'm just making this up, but 99% of the time, the appointments are as a best interest attorney, sometimes in a very limited role as an attorney to waive the privilege without getting into that. But if a child is seeing a therapist, for example, and the therapist, chances are, has some pretty good information
Right.
that would be good for the decision maker. Attorney might be appointed in that role. That's pretty common, but the advocate not. So no data, and I talk about this now ever since becoming more involved with this project. I ask people all the time. Here's something else, and this you may be getting ready to ask me this. Um, are you going to ask me why?
Sure. Yes. No, I was.
Or
Yes.
not? Okay, so that
Why?
was putting you on the spot
Why
there.
is that? Yes.
Or so, and when I ended up having some very informal kind of interviews of the attorneys who responded and just talking now to people when I'm running around doing my thing around the state. It's interesting to me that most attorneys and judges and magistrates um, think that a best interest attorney is the most appropriate because what the heck do kids know about anything? And they're just going to be coached anyway. And I found that surprising, but that is, as we've talked about, our kind of little group, Child Voice Project staff and Connie consultant, that's our big uphill battle. By the way, that's the big uphill battle because a lot of people, and I dare say the majority of the bench and the bar, think it doesn't make sense to have a child advocate. So, lots of education and research to share from the Child's Voice Project as we go forward on the
Yes.
benefits, right?
Yes. And we are very aware of the gap in this field. And um, I appreciate you sharing the the uphill battle, which I think happens, in different places, even places where there is not a statute. Um, People take that attitude, adults take that attitude towards children. So it makes sense. And you also mentioned the child's going to be coached, and we have talked about coaching, and we will probably revisit that topic in 2026 because it's a very broad topic and one that can the perspective on it, as Dr. Steph will say, that of course children are coached. Children are supposed to be coached. They're coached by their parents, and in the sense of influenced. And so children are influenced by all sorts of things. That's how they're raised in our society, is to um, be influenced by all of these different factors. And so it's definitely something that we are taking head on. So great. And I am curious, as you're talking about education and research, um, in one of your prior roles, I think you also developed some training for child advocate attorneys. Can you tell us about that?
I can tell you about that. So when I joined the Maryland Judiciary, that was fall 2007, my first kind of project that the executive director, Pam Ortiz, who I mentioned earlier, first big project she assigned to me was um, coordinating and developing the trainings to implement the new 9-2051,
Okay.
which was the child counsel rule. And as part of the rule and pursuant to the guidelines that the judiciary adopted as part of the rule, lawyers were required and are required to attend at least actually, I think it's 6.5 hours of training.
Okay.
So what I did, I wasn't the person up there. I did a little, I would do a piece pretty much at all the trainings, but I wasn't like the main um, presenter. Frankly, I was more like the project manager. I was more like the GM, the general contractor, kind of reaching out to the wiser, more experienced people around the state who who had a lot of knowledge of child custody, either as attorney practitioners, mental health people, psychiatrists, people with knowledge of domestic violence, all of those kind of folks we brought together. And I think I did a good job. And I thought they were good trainings, but this is probably kind of blasphemy, but um, 6 hours ain't nearly enough. That's crazy, But at least it's a start and it's something. And again, that's a great opportunity for Child's Voice Project, to have more comprehensive, fuller, ongoing trainings and attorneys who are in this role. Whether it's as a in any of the child counsel roles, whether it's a
Right.
best interest attorney, child advocate, or a to a lesser extent, but a privilege attorney. Yeah, so we did those all over the state. Every region of the state, some of you on the call perhaps even went to them. We all over the state, Western Maryland, Eastern Shore, Central Maryland. We did it for years, and then after a while, um, I think it was probably in more information than you need, but I feel like I'm becoming one of those older people who like goes on and on because I've been around for a while. All right, Grandma, enough already. We've heard enough. So it's okay. You just give me the nod or, send me something in the chat just to me if that's enough, Connie.
You're
Um,
doing a great job. You're doing a great.
Okay. But when there was a new chief, now we call it a chief justice,
Okay.
brought on, then we had a new court administrator, which is the highest administrative official in the judiciary, and that was my boss. Um, that that the court administrator didn't think it was really the role so much of the judiciary to train attorneys. So now those trainings are conducted by the state bar or other folks, and people pay for it. When the judiciary offered it, attorneys didn't have to pay to
Wow.
go. So there's some debate about that, if that's better or worse, whatever. The people who are conducting it now also, it's pretty much the same people who I brought together, or in some cases, it's kind of sweet. Their progeny. Um, anyway, so they're still going on. Those are offered a couple times a year. So hopefully that answers your question.
It does. And I'm curious, were there child development components that were provided to the attorneys you were training at the time?
Yes, that was absolutely part of it. But again, if it's 6 hours, it's we did what we could in the rule, that's you work with what you have. That's what the rule says. So, but there wasn't that much. But yes, there was absolutely a component, and there was a domestic violence component. Again, not really enough, but it was something.
Was there a continuing nature of the training so that people had to go back every year or something else like that?
So funny you should ask. The answer is no. Maryland is one of probably 4 or 5 states that does not have a requirement for mandatory continuing education. That's almost certainly to change. I mentioned earlier in our conversation, I'm the co-chair of the State Bar Rules Committee. Um, and almost my prediction, okay, here's a hot take, people. You heard it here first. Almost certainly there will be a mandatory continuing education requirement for attorneys to maintain their licensing in Maryland. It's kind of a hot topic. You would think that's a no-brainer, right? You would think that's you would think that's a no-brainer. But there's a lot of concern from particularly almost exclusively practitioners that it's expensive to do continuing education. And there's some legitimacy to that argument, particularly if you're a nonprofit legal service organization. You get all your funding to pay for your attorneys through grants. And for those of us who work with legal service nonprofits, we don't get a lot of grants for training.
Right.
Um, but that's probably going to change. And again, that opens up another opportunity. I'm seeing a theme here for Child's Voice Project and expansion.
Yes, I appreciate that. And there are certainly obviously different methods, charging per credit hour versus having a flat fee. And I'm sure Maryland is going to take best practices from around the country. Um, so you've already sort of touched on this, but I'll still ask in case there's something more. How are you using that experience from that training that you did, and then just also your prior experience at the judiciary? How is that helping you in your work with the Maryland Child Advocate Attorney Pilot Program through Child's Voice Project?
Gosh, in so many ways. So if there's something I haven't already said, well, one, the sort of threshold issue is because of that work, um, and working so closely with the court judges, magistrate, court administrators, court personnel in the family divisions, family support service coordinators, all those folks who um, identify services or evaluations. For example, a family might need in a custody case. So all of that, I'm very familiar with these people
Mhm.
around the state. So it's helpful from a very practical standpoint of, frankly, access. Oh, it's Connie. Boy, you still around? When I call, they know I've been around and I have some history and I maybe have some knowledge and experience. So that helps, and that's kind of what I bring to CVP and our partnership. Um, but it also that experience, as I've mentioned before, and I'll maybe be looping, which by the way is what I would accuse my mother of doing, of repeating, like you already said that. So I have fully embraced and internalized all of these things, as I think we adult children tend to do. Um, but it also highlighted for me the need to enhance what we have. The rule we have is a magnificent start. It was a great start, and it was the beginning of more codified quality control. And Maryland has done that in many ways, including, which I played a role in having some quality control, for example, in attorneys and in guardianship cases and guardians, whether person of the property in guardianship cases. We need more training. We need more continuing education. And like I said, that 6 hours is not enough, but it's a start. We have the foundation to expand. So I think that's probably all I can think of in answer to the question.
That's great. Thank you. All right, want to transition again a little bit. So you talked about loving rulemaking, and so it's not a surprise that you're excited, but you have told us previously about the custody factors in Maryland. I don't think you've mentioned it yet today, but it's something that definitely was present in the training that you did with the attorneys for the pilot. Can you tell us about this significant advancement in Maryland law, when the law will take effect, and why the adoption of custody factors is so meaningful?
Oh my gosh, I could talk for ages about it. Okay. So again, um, up until this past legislative session, the 2025 legislative session, Maryland had been one of, I guess, 4 or 5 states. We're like one of five with so many things. In the work I've done, I've had occasion to do like the national landscape of what other
Yeah.
states are doing in a particular area of the law. Um, Maryland had been one of 4 or 5 states that did not have a statute enumerating the factors a judge is to consider, or the court is to consider, because we have magistrates making the recommendations first, but whatever. The court is to consider when making a custody determination. So finally in 2025, Maryland adopted a statute that enumerates the factors. There's 16 factors. Of note, I think it's factor maybe 15 that says that the court should also consider the desires and preferences of the child. Not that the court couldn't do that before. And why that is, there we go, if age appropriate. Yep, and it's Senate Bill 548. So that, for people like me and probably a lot of people on the call, this is a very big deal because before what Maryland, the law was, the court makes a decision based on what the court thinks is in the best interest of the child. Now, that hasn't changed, but it means whatever the heck the judge thinks is in the best interest
Right.
of the child. And of course, having been with the judiciary, my brother's a judge now. My dad had been a judge. I love the judges. We got great judges, but judges, there's a spectrum of decision making with the judges, and some are better positioned than others, and they maybe didn't have to consider these factors. So now they do, and it becomes effective in answer to your second or third part of that question, October 1st. So that's just a couple of weeks. It's magnificent. It's interesting. I mentioned this in one of the trainings. I think it's curious in the drafting. I don't know if it was inadvertent or some sort of compromise um, in this last session, but says the court may consider one of these 16 things, but the subsection B of that statute says, but the court must articulate and explain, either on the record or in the written opinion,
Right.
what the court thought about each of those factors. So that's a must. It's a big deal. It's huge. It's one of the best things. And I am particularly fired up about it because back in 2013, um, my office in the judiciary was required by legislation at the General Assembly, instead of making a decision on whether or not to have factors, because that was going on for decades. And those of you on the call may be familiar with this, but for decades, there has been these battling bills filed in the Maryland General Assembly. One was to have factors. For God's sake, we need factors. Everybody else has factors. Shouldn't people know what the heck the judge is thinking about when judge is deciding where my precious little bundle of joy is going to be? I mean, it's a really big deal to people. And they should have some sort of idea. So that's bills like that have been filed for decades. But at the same time, the competing bill has been filed to have a joint presumption of custody. The starting point for the court, some argued, should be both parents are equally. We need to assume that both parents are equal in their ability unless one or the other shows otherwise. And in a way, mathematically, that kind of makes some sense, but you can see why maybe that's not great. That means you're almost required then to tear down the other side. Anyway, it's been, and those bills, and I'm not taking well, you might have an idea of my position on that, but regardless of my position on that, those bills were generally being advocated by the fathers' rights groups. Oh, the poor guys are being taken advantage of, and in these cases, and oh, the poor fathers. And yes, there are poor fathers sometimes who are taken advantage of, but there's kind of some data to counter a lot of that, particularly by the National Women's Law Center. Another topic, perhaps another roundtable. But because of that, what legislatures do all over the place, whether state, federal, whatever, county council, when there's a hot topic and people feel strongly on both sides, then they have it researched. Let's send a task force to look at that and make up some recommendations and buy us some time. So in 2013, the legislation was passed that said, I'm looking at the time. I better wrap this up. Let's have a commission created to investigate how the courts make custody decisions. And the commission was cleverly called the Commission on Child Custody Decision Making. And I staffed that commission, and we had the attorneys in my office, we had subcommittee meetings for 16 months. As part of the final report, we drafted a statute, and the statute has had our draft statute had factors, and that's about what was adopted this last session. So I myself am personally just super excited that that was adopt it because it's another movement in the right direction. And right now, with all going on in the world, regardless how people feel, it's really nice to have some progress and reform. So amen on having some factors.
Excellent. Thank you so much for that. And as you mentioned, we are coming towards the end of our time together. We have so appreciated you being here with us. My last question for you is what your goal is for the pilot project that Child's Voice Project is holding in Maryland.
So you're going to love this. I
Yes.
can answer that in one word: expansion. Expansion. More courts in Maryland doing this, more courts everywhere doing this, and really zooming out. And kind of how we started the conversation or early in the conversation, um, giving all parties and individuals affected by a conflict, giving them voice means better outcomes.
Mhm.
So, expansion.
Excellent. Very well said. Thank you so much. As we near the end of our time together today, we so appreciate you, Connie, for joining us as our first guest expert. And we thank everyone else for attending as well and being part of this developing cohort. We want to remind you that our next roundtable is on Wednesday, October 15th. We will interview some of the attorneys representing the child clients through Maryland Child Advocate Attorney Pilot Program, and we hope that you will join us again. So thank you and have a wonderful rest of your day.
Okay, and thank you again for including me.
Thanks, Connie.
Are we staying on this call or logging off for a follow-up?
No, I think Emily's going to end the